Hi, I'm Ethan,
Hi, I'm Jackie,
and we are Plan Well to Live Well.
and today's topic is Inheritance and the Secure Act 2.0.
All right, Jackie. So, what do we got for our viewers today?
We need to learn and understand how to protect a lot of stuff. So I'm relying on you, Ethan, to guide us down this road of the Secure Act.
There's something called required distribution. So,
Right.
this is typically for people who have IRAs, 401ks, and 403bs, and maybe there's some other types of acronyms there. But required minimum distribution is something where the government has created a retirement plan and allows you to defer pre-tax money if you're lucky enough to start planning when you're 18, or if you're lucky enough to have an employer that helps you set up a retirement account. The government allows you to defer and not pay taxes for quite a bit of time. It could be 20, 30, 40 years, depending on how old you are when you start planning.
Right. So isn't that age, the planning age, starting at, I'm required at age 72, and it was recently increased to age 73. Am I correct?
Correct.
Okay.
So it used to be that at 69 and a half,
Okay.
if you had an IRA and you weren't working, the government forced you to take what's called a required minimum distribution. Essentially, let's just say that if you had $100,000 and at 69 and a half, this is prior to 2000, you had to take about 4% out. So you had a $100,000 IRA, a $100,000 401k. You had to take out $4,000 required minimum distribution. So now, in the Secure Act 2.0, they changed that to 73. So
Okay.
I'm wondering why they do that.
At age 72, your income has shifted. And so from 69 and a half, you may still be working full time. So you're in a different tax bracket versus at age 72 or even at age 73.
You know, I have an example. I have a client. He's basically 70. This is a couple of years ago. He was like 70. He's a computer programmer and he's making $120,000 a year. And then he's got an IRA worth about $1 million. So he gets this $40,000 RMD and he has to give Uncle Sam $12,000 in tax.
Of his own money.
Of his own money. And he was so grateful that they delayed it to 73 because he's still working. He's not quite 73 yet, and he doesn't have to collect his required distributions. Uncle Sam lets you defer. And the earliest you can take is 59 and a half. If you take earlier than 59 and a half,
There's a penalty.
there's an early withdrawal penalty. Unless there are some, we call like hardships and medical, but that's something
That's a whole different
that's like the
conversation.
IRS has to approve that, and your accountant files that. I'm not exactly sure, but anytime you have to prove certain situations have occurred for the IRS not to charge you the early withdrawal penalty. And it used to be that I could inherit that IRA and stretch it over my entire lifetime. Well, the Secure Act 2.0 says we're going to let you wait until you take it. But now when you take it, your beneficiaries have to liquidate your account within 10 years. So Uncle Sam says, well, we don't need to collect your tax at 69 and a half. We can start collecting it at 73. But if you die without taking all the money, your beneficiary now can't collect it over the lifetime. Your beneficiary now has to only collect it over 10 years.
My oldest sister, she's 74 years old and she's still working full time. She's collecting her Social Security and now she has to collect this required distribution. And she's feeling the pinch of how the tax implications that all comes with that.
Right.
So I've finally convinced her now to let's have this conversation with a financial advisor so we can we can't eliminate the tax burden. However, we can find other strategies that we can talk about of how to just reduce some of that. Because she too doesn't need the required distribution because of her salary working full time, because of her Social Security income. She's more interested in the education piece and the value that I can provide or our team can provide her in that direction.
If you're still working and you have your work 401k, or 403b, even though you're at 73 or older, you're not required to distribute from your employer plan if you're still working in your employer plan. But you do have to distribute from the other assets that are not connected to the active employment. I've had some people that are distributing from their IRAs, but they're not distributing from their 401k because they're still working.
That's right.
With the Secure Act 2.0, they made another law. I believe in 2025, they're going to mandate that the employers must, if you're an eligible employee, must automatically enroll you into a 401k or 403b and use a minimum pre-tax percentage of 3%. So let's just say you make $1,000 a week. They're going to hold in your 401k a minimum of 3% pre-tax, which is $30.
I like that because it forces the person that's the employee to start asking questions, to start educating themselves on how it works. You're getting free money. If someone's going to match your $30, that's free money.
Get your free money.
Get your free money. You've earned it.
Right.
And you're doing your planning so that way 10 years from now, 5 years from now, you're starting to build that nest egg. That's going to be so important in retirement.
If you start saving in 40, great. God bless. Thank God you started saving in 40. But if you start saving at 18, the power of time, maybe we can find like a little data point of, if you start saving 1,000 when you're 18, or start saving 1,000 when you're 40, the compounding effect of not saving for 20 years versus saving for 20 years. That's a
huge number.
A huge number. And you don't need that much if you actually start early, but when you start late, you need to put in so much to catch up those 20 years of compound. So Jackie, the rest of our show for our viewers, we wanted to also kind of talk a little about inheritance.
Yes.
And what is really inheritance for people as you kind of deal with it.
It all has to start with that designation. So when we talk about inheritance, in a previous show, we talked about inheritance and how it's designated as a beneficiary.
Right.
So that beneficiary, if it's designated on a life insurance policy, an annuity, a 403b, a 401k, that individual now can inherit money that's coming to them probate-free and tax-free. So again, going back to what we said earlier, that designation, that inheritance is so important. It's how it's documented on these different financial vehicles.
Let's talk about the difference between an heir inheriting your real estate versus a beneficiary inheriting your IRA stock account. Mm-hmm. So an heir will inherit your asset through the will.
That's right.
While a beneficiary will inherit your asset without a will, privately, outside the probate process. And I remind a lot of my clients that Uncle Sam is a child that you want to cut out of your will. You want to cut him out of your beneficiary designations. But Uncle Sam, you can't just cut him out. You could limit the burden that the family has, and you could potentially limit some of the tax if you do proper planning with heirs and beneficiaries. An example, a parent leaves $100,000 to their child, 3 or 4% just comes off the top for inheritance. Boom, it's just, and then depending on the asset that you left someone, there could potentially be some income tax, there potentially could be some capital gains tax.
Can we put some of those vehicles into a trust to hopefully, again, not to cut Uncle Sam out because he's coming for his, but to soften the burden?
Typically, there's something called a funded trust and an unfunded trust. So a funded trust is, let's just say, Jackie, you own a house. Mm-hmm. And currently the house is owned by Jackie Berrios. Yes. When you pass, you direct in your will that your house goes into a trust called the Jackie Berrios Family Trust. So that particular trust is called unfunded. You set up a trust, a box called Jackie Family Trust. It sits empty until you die, when the will or your beneficiary designation specifically state my assets don't go to my daughter. My assets go to the Jackie Family Trust. So you can direct your assets in the beneficiary designation to go to your trust, and you can direct your assets to go to the heirs in the will to your trust. So that's called an unfunded trust because the assets are in your name and they waiting for this box for you to die. And then when you die, then the assets flow into the trust. And then there's something called a funded trust, whereas you, Jackie, while living, sell your asset, your house, to the trust. You have rights to stay in the home, but the owner of your home is the Jackie Family Burials Trust. Either the trust owns your asset, funded trust, or unfunded trust where you still own your asset, and then when you pass, the assets pass to the trust. So I get a call from one of my clients, and she says, "Hey, I have a trust." I said, "Great. Well, what kind of trust do you have?" She says, "I don't know. I have a trust." I said, "Well, it doesn't matter if you have a trust. Your beneficiary designation says everything goes to your son. So your trust can say everything goes to me. Everything goes to your sister, brother. I don't even care what it goes to. But your trust does not supersede the beneficiary designation in your IRA. Your trust does not supersede the beneficiary designation in your life insurance. Currently, the contract in your life insurance that you have between yourself and the life insurance company says your beneficiary designation is your son. So when you die, your trust will not get that life insurance asset." She goes, "What do you mean? I wanted to go to the trust." I said, "Well, maybe when you were meeting with your attorney, I'm sure he said it to you. That's part of the process. But maybe he didn't elaborate, or maybe he didn't,
Right.
He did his job as the attorney, and he's not your financial advisor. He's just your attorney. Most likely, your attorney said to contact your financial advisor or your insurance company or your IRA and change the beneficiary." So I said, "I'm glad you called me, because if you didn't call me and tell me you had a trust, your son will get your IRA that our firm is handling, the life insurance that we're handling, and your trust would absolutely get nothing. So you have an unfunded trust." And so the moral of the story is that we had to, almost like we had a show. Why do people need to look at their beneficiary designations?
That's right.
Marriage, death, new child, and so forth. Well, another reason why people should look at their beneficiary designations if they're planning an unfunded trust or a funded trust, whatever the case. If they're planning a trust, they want to make sure that the beneficiary designation tells that it goes to the trust, not to an actual individual.
And that's why I love what we do and I love about this show, because we're educating folks. This person had no idea until they made the phone call to you about where they stood with their financial vehicles that they had in place and how it will affect their beneficiaries and how it will affect them in terms of the inheritance. Just overall, the pure education, because no two situations are the same.
Right.
And crafting the right path for this beneficiary to receive this inheritance, whether it be in the trust, outside of the trust, funded, not funded. So all of those different variables weigh in on how someone makes a decision in their financial planning.
Our customer is the captain, and we're the players. We are the players, which includes the attorney, which includes the accountant, which includes the insurance agent, which includes the financial advisor. And typically, in our scope of work, I try to
include everyone,
connect all the dots, and then also try to include the beneficiaries or the heirs into the conversation, because we had a show. The son didn't know the mom left the life insurance, and the son never collected it, and it became unclaimed assets. So it's important for our viewers to know that if you're thinking about planning, no matter how big your estate is, no matter how small your estate is, it requires a team. And Jackie and I are committed to helping you coordinate that, because it's very complicated. It's interesting for us. I love this information, but it's very complicated stuff. I mean, you have to go get all these licenses and all this education to be able to do that. And for the average person, it's difficult to get all this information that's out there.
That's right. And no two situations are the same. It's very unique. So, Ethan, we had an amazing conversation. Almost we went down a rabbit hole.
We could do this for another hour or two.
Yeah, and just talk about the implications of inheritance versus beneficiaries versus heirs, the Secure Act. But most importantly, if you have any questions as it relates to the conversation that we had today, we encourage you to click the link in our bio and secure that free information, education, no obligation consultation, so that way we can speak specifically to your situation and get you down the right path as it relates to planning. So you know what we always say, when you plan well,
You live
live
well.
well. Again, thank you so much for
Thank you, everybody.
and have a great day.